Good morning, everybody. We have a hot topic today. Welcome to social media and academic freedom under Garcetti. My name is Liesl Zwickelbauer. I'm the Assistant Vice Chancellor for Employee Relations at the State University of New York. You cannot hear me? No. Can you hear me?
Yes.
I'm loud in my own. Oh. Okay. Bill Herbert and the National Board have put together a distinguished panel on the topic of social media and academic freedom. We have with us today Marjorie Hines, Teresa Chmara, and Frederick Schaefer. Marjorie Hines is the author of Priest of Our Democracy, the Supreme Court, Academic Freedom, and the Anti-Communist Purge. There is a flyer on all of your tables about that book. She has been a fellow at the Brennan Center for Justice. She has directed the Arts Censorship Project with the American Civil Liberties Union. For all of you, there are more extensive bios in the material that came with today's program if you're interested. Teresa Chmara is the General Counsel for the American Association of University Professors and General Counsel for the Freedom to Read Foundation and a board member of the American Booksellers Foundation for Free Expression. And Frederick Schaefer is the General Counsel and Senior Vice Chancellor for Legal Affairs at the City University of New York. Prior to that, Mr. Schaefer was in private practice at a New York City law firm and engaged in employment law. He was also an associate professor at the Benjamin Cardozo School of Law. Welcome, everybody. If everybody could please turn off their cell phones. We are videotaping this event today, so it will be available as a webcast somewhere down the road by the center. Hopefully everybody is okay with being filmed. If you have questions, I will be trying to walk around the room later with the microphone so you can ask questions. And when I do, please identify yourself. We are going to start with Marjorie, and she will talk about academic freedom and the First Amendment. And then Rick will talk about academic freedom and its application to public sector employees. And then Teresa will actually get into Garcetti and the application of Garcetti in the academic settings. And then we will get into a little bit the social media aspect and hopefully have many questions and issues for you to present to us. Marjorie?
Good. Everybody hear me? Hi, thanks for coming. It's great to be here. And as Liesl said, what I'm going to do is try to lay out some background of how academic freedom developed, both as an educational policy concept and ultimately in the late 1960s as a special, quote, special concern of the First Amendment, quoting the language of the great case of Kayishian versus Board of Regents, which is sort of the culmination of response that the Supreme Court had belatedly to the prolonged period of political repression, sometimes known as the McCarthy era, which hit teachers and professors particularly hard. So there's a lot that happened after. Kayishian was sort of the culmination of this process, a lot that has happened afterwards. I'll end my talk with just pointing out a few of the questions that are open after Kayishian, and Rick will pick up from that. And we will try to apply all this complicated legal and political situation that we're in now to social media in our discussion. And one thing we'll talk about is a policy that's in your materials at the end of, I think, the materials I prepared. Kansas board says universities can fire employees for improper tweets. So policy by the Kansas State University system, very broad restrictions on free speech for faculty using social media. Anyway, so a lot of this, a lot of the research for the background that I'm going to give you came as a result of first my work as a First Amendment lawyer at the ACLU in the 1990s, and then research for Priests of Our Democracy, which Lisa was nice enough to mention. I've got a couple of copies of the book if you're interested in looking at it afterwards, and there's flyers. There's more flyers out outside on the table. So let's start with the beginnings of the idea of academic freedom, and this is really late 19th, early 20th century. Professors, America is a country with mostly a long tradition of at-will employment. Professors beginning to get active, some of them in the late 19th century, in support of labor union organizing. Boards of directors of universities dominated by corporate executives are not happy with that, and there's a series of rather high-profile cases in which professors are challenged, fired, retaliated against for their outside political activities. But as we'll see, what is an outside political activity and what is part of the professor's job description, teaching and scholarship is sometimes a hard line to draw. So this goes on, and finally in 1915, a group of prominent professors get together and form the AAUP, the American Association of University Professors, and their founding document, the Declaration of Principles on Academic Freedom and Tenure, and the two were considered inextricably linked, basically set forth an argument for why teachers in higher education should be treated differently from other employees, and then set out a basically three-part definition of what academic freedom, first why they should have academic freedom, and second what it consists of. And the justification, the document's interesting because it sort of goes back and forth with a kind of between a kind of elitist justification and a populist democratic justification. The argument is not that professors are super smart and therefore should get special privileges, but that they serve all of society, they serve democracy by educating. And the process of education is a process that requires free inquiry and freedom of expression, and therefore the university is a different kind of employer than other corporations. So this is a justification, and it's a theme that you can see running through arguments about academic freedom for the next century, and eventually makes its way into Supreme Court case law as well. So the three prongs of academic freedom that the Declaration sets out are classroom teaching, freedom in classroom teaching. None of this is unlimited, of course. With rights come responsibilities, etc. Freedom in classroom teaching, freedom in to inquire into your scholarly area of research and publish without restraint. And the third prong, something called extramural speech. In the days when universities had walls and there were no electronic communications, speech outside the walls of the university, what we would consider today political communications as a citizen on matters of public concern. That was considered part of academic freedom as well. I hear from Rick, and part of the reason for that is there was no general protection for employees, public or private, against retaliation for their outside political activities. So it was thought as part of the teacher's responsibilities and rights and the ability of the teacher to communicate freely, that the extramural political activity also had to be protected. So there are periods of, you look at American history, there's a cycle of periods of political repression and then more relaxation and more liberalization. And you can see that certainly starting very shortly after the AAUP founding and declaration with the first big Red Scare after World War I. So although the AAUP principles are being more and more widely accepted as a matter of policy, we can also see through American history that in periods of political panic, political repression, Red Scares, the universities don't do a very good job of necessarily defending these principles. So meanwhile, what's happening in the courts? This these very ambitious principles have now been articulated and are gaining traction in the policy arena. The Supreme Court, as usual, is a little behind, and in this era, it is only just beginning to look at what restrictions the First Amendment might impose on the actions of government. And at first, there's really no limits. Early case, as I'm sure you know, protesters against World War I are jailed for long periods of time for basically dissent and protest. The Supreme Court says that's fine. Eventually, by the 1930s and 40s, the court is starting to impose some limitations on what agencies of government can do. A lot of cases do involve labor organizing. But there's still really nothing in terms of academic freedom, protection specifically of teachers and professors from retaliation or repression. So then we get to the most prolonged period of political repression in the United States, the so-called McCarthy era, starting really almost immediately after World War II and lasting well into the 1960s. And the Supreme Court and teachers and professors are particular targets of anti-communist rhetoric, political investigations by legislative investigating committees, loyalty oaths, administrative apparatus that gets set up around the country to investigate political associations and political loyalty. And New York City is sort of a hotbed of this because it had been a center of radical left-wing activism, and so the reaction in New York City is particularly severe, and a lot of the cases that I investigated, of course, writing Priests of Our Democracy, actually come out of New York City and State. So the first case in which the Supreme Court is confronted with a kind of academic freedom argument, a free speech argument, a challenge to a law, New York State law, but very typical of laws, both federal and state, all around the country. This law is called the Feinberg Law. It gets passed in 1949, and it basically piggybacks on two earlier laws in New York State from two earlier periods of political repression, one from just after World War I and one from the 1939-1940 period, laws which basically restrict the political activities and associations and beliefs of teachers and professors and other civil servants, public employees. The earlier law basically made it a disqualification from employment to engage in any seditious or treasonable activities or make any seditious or treasonable utterances. And the later law was quite similar, but was framed in terms of belonging to an organization or adhering to any set of beliefs that included the overthrow of the government by force or violence or other unlawful means. So basically believing in revolutionary doctrines. So these laws are on the books, but how do you enforce them? And what the Feinberg Law did was put into place a massive system of administrative enforcement, implementation of these laws. Every teacher, every public employee, but including every teacher, would be investigated, reports would be made, informers, of course, would be invited to come forward with information. People would be asked about their political beliefs, and a purge begins throughout New York State, including especially New York City. And a group of teachers, teachers' union in New York City, a radical left-wing activist union, parents, taxpayers, combine to challenge the Feinberg Law. And they actually win in the first round. There are two parallel cases, and lower court judges in New York State, relying on some of the Supreme Court decisions having to do with labor organizers and Jehovah's Witnesses and so forth in the 30s and 40s, say this law is unconstitutional and interferes with freedom of expression of citizens, has no particular relation to teachers' ability to do their job. That's quickly reversed by the appellate courts in New York. Case gets up to the Supreme Court. The case is called Adler versus Board of Education, decided in 1952, and it's in Adler that we see the term academic freedom in the Supreme Court opinion for the first time. But it's in a dissent by William O. Douglas. It's not in the majority opinion. You won't find it there. Adler is I think in retrospect it's probably fair to say, not very well-reasoned piece of jurisprudential analysis in which the Supreme Court majority basically says, you have a First Amendment right to believe anything you want, to join any organization you want, you just don't have a right to be a teacher. And the school system has an interest in investigating your political beliefs and associations. But Douglas writes a dissent, as he will, along with Hugo Black in many of the cases of this era. And he points out some of the problems with a system of political investigations in which people are going to be spying on each other, and ears will be cocked for telltale signs of disloyalty, he says. And then he talks about academic freedom. He says this law will raise havoc with academic freedom. A pall is cast over the classrooms. And this language, this metaphor of a pall being cast over the classrooms will come back 15 years later in the Kayishian case, which I mentioned, when the Supreme Court finally, by a very narrow majority, will overrule Adler and strike down the Feinberg law. But it takes 15 crucial years in which basically McCarthy-era type investigations, loyalty oaths, purges are going on with approval from the Supreme Court. But Douglas has articulated the alternative view under the First Amendment, and he has linked this, the Feinberg law appears on the surface to be directed at extramural activities, associations. Have you gone to the May Day parade? Have you joined the Communist Party? Have you left the Communist Party? But he makes the association between that and what goes on in the classroom. A pall is cast over the classrooms. There needs to be freedom for teachers, and the Adler was about public school teachers. It was not about professors who actually, state university employees got added to the Feinberg law a couple of years after Adler. So even at the high school and perhaps even lower level, Douglas is setting out this vision of freedom of exchange and expression and ideas in the classroom. Okay, so in this period, the Supreme Court is pretty much approving any initiative that a legislative investigating committee, an administrative agency, a lower court will take in pursuance of the anti-communist agenda. But there is a case later in 52, and this is sort of the second mention of academic freedom in the Supreme Court, and it comes in a concurrence in a case. Concurrence is by Justice Frankfurter, who, as some of you may know or remember from law school, was a great advocate of judicial restraint. He might disapprove of something, and he would say so at length in a concurring opinion, but it wasn't the job of the courts to wade into the political battlefield. The other branches of government decided that a particular program was appropriate. But Frankfurter was not entirely consistent, and when it came to academic freedom, he made a big exception. So this case later in 52 is called Wineland versus Updegraff. It comes from Oklahoma. It's a typical state loyalty oath requirement for public employees, including teachers and professors in the state system. It's not one of these sometimes considered innocuous loyalty oaths. I pledge to support the Constitution. It's what we call a negative loyalty oath or test oath. I pledge that I have no ideas that are subversive, or I don't believe in the oath of government, and I've never been in any organization that had such ideas. So the oath is challenged by a group of professors in the state system in Oklahoma, and the court finds a narrow ground to strike it down. The oath didn't include a scienter requirement, a knowledge requirement. You could have joined a subversive organization because you were drunk at a party and you left a week later after you sobered up and you never knew it had an unlawful aim to overthrow the government. So the Supreme Court majority thought that by imposing this not requirement of knowledge, I have not knowingly joined an organization, that would somehow fix things. It had made absolutely no difference in terms of the political situation. But there was a narrow ground, and occasionally the court would do this. It would find some narrow ground to chip away at some loyalty program that seemed overly broad. Well, Frankfurter writes a concurrence, and he says, basically, to hell with this narrow ground. This is about teachers. This is about academic freedom. And although he doesn't usually use that term, he does say, and this is the language that I used for the title of the book, the oath threatened that free play of the spirit which all teachers ought to, especially to cultivate in practice. Teachers are the priests of our democracy. Because it's their job to foster those habits of open-mindedness and critical inquiry, which alone make for responsible citizens. So we now have Douglas in a dissent, Frankfurter in a concurrence, talking about this idea of academic freedom and its importance, as the AAUP said in 1915, not because teachers are special and smart, but because they are performing an essential function for democracy. Responsible citizens. Okay, so I'm probably already going over my time. I'm going to try to speed up the rest of this story. Fast forward 5 years to 1957, and finally we get a Supreme Court decision in which you could basically say a majority is now recognizing a right to academic freedom within the umbrella of the First Amendment. And first, there's this plurality opinion by Chief Justice Warren. The case comes up out of New Hampshire, where a Marxist but not communist professor named Paul Sweezy was being interrogated by the New Hampshire Attorney General, who has set himself up as a sort of little anti-communist one-man investigating committee. Sweezy is cooperative. He's being asked about a lecture he gave at the University of New Hampshire, but there's some questions, a few questions he won't answer. And he's found in contempt of court, and the case goes up to the Supreme Court. And now it's a Warren court, and there is a small, uncertain, delicate, shifting, but often a majority, beginning to be a majority in favor of more liberal view of First Amendment rights. And in Sweezy, Warren writes for plurality, and he doesn't decide the case on First Amendment grounds. He decides it on due process grounds, but he basically says the scope of the Attorney General's investigating authority was so unclear that Sweezy, there's no right to sort of just investigate and expose political beliefs for their own sakes. Sweezy couldn't know what the limits were. So the decision is narrow, but the dicta is very broad. And Warren articulates an underlying reason for the due process decision. And this is language that's been quoted many times. The essentiality of freedom in the community of American universities is almost self-evident. To impose any straitjacket upon the intellectual leaders of our colleges and universities would imperil the future of our nation. So pretty strong stuff. And Sweezy is quoted a lot for that principle, although it wasn't the holding of the case. But then again entered Justice Frankfurter, and he writes a concurrence. And our apostle of judicial restraint, Justice Frankfurter, would go further than the majority and would decide the Sweezy case straightforwardly on First Amendment academic freedom grounds. And Frankfurter quotes from a statement that had been put out by some South African scholars, and he identifies 4 essential freedoms of the university: to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. So these 2 eloquent opinions about academic freedom, but watch out, because there is a little conflict brewing here that neither Warren nor Frankfurter may have been aware of at the time, because Frankfurter had this vision, which is still very much a vision, although much challenged vision these days among the professoriate, that we are the university. We, the scholars, collectively decide who may teach, what may be taught. There's really no distinction between the university as an entity and the individual scholars. That was probably Frankfurter's naive idea in 1957. It's become a more and more naive idea, as we know, as university administrations have become larger and larger, and there has been more and more conflict between the individual professoriate and the university administration. But Sweezy decision is sort of the germ of this dual concept of academic freedom under the First Amendment. Is it the right of the individual professor and his or her students? Is it the right of the university as an autonomous entity? Okay, so I'm going to fast forward 10 years to the Keishian case, sort of the culmination of my saga. In that intervening period, 57 to 67, the Cold War is beginning to abate, but not very much, really. The Vietnam War is raging by the mid-60s, American intervention based largely on Cold War domino theory. We've got to stop the communists kinds of thinking. There's a couple of cases in the early 60s where teacher loyalty oaths are struck down on grounds of vagueness and overbreadth, or there's no scienter requirement, stuff like that. But it's not until the Keishian case in early 67 that the court straightforwardly, and again, as I said, by a very narrow majority of 5, decides wholeheartedly and straightforwardly to take on the entire kind of investigative system of political loyalty and guilt by association that has been dominant in many fields of American life, including academia and education, since the late 40s. Keishian comes up out of the University of Buffalo, which had been a private university, and gets absorbed into the state SUNY system in the early 60s, and the Feinberg Law suddenly applies to all staff, including professors at the University of Buffalo. What the SUNY trustees have done in order to manage this huge task of investigating the politics of every employee is to create a loyalty oath, essentially. It's called the Feinberg Certificate. And instead of having your department chairman do an investigation of the political associations of every professor, everybody simply has to sign the Feinberg Certificate, in which you swear you were never a member of the Communist Party, you don't believe in revolutionary doctrines, and if you were ever a member, you have informed the president of the university. So the faculty is up in arms. Nobody wants to sign this thing. It's insulting. It's now the mid-1960s. But the SUNY trustees are pretty intransigent, and it turns out there's angry AAUP meetings. At the end of the day, only 5 faculty refuse to sign. And they are sure that they can get the Feinberg Law struck down, even though Adler is still the reigning precedent, and everybody's telling them, including the law school faculty, which writes a memo on the issue, you're going to lose. And indeed, they lose in the lower courts. They get up to the Supreme Court. And it's a very interesting story because Brennan writes the opinion, and there's a wonderful memo from the clerks, Brennan's clerks for that year, describing the process of decision-making. Abe Fortas was on the court, fortuitously, for a brief period of time, and Fortas becomes the 5th vote. Fortas is very much on the line about, are we going to reaffirm Adler and uphold the Feinberg Law, or are we finally going to put an end to this long period of investigations and guilt by association in the sphere of public education. And so Fortas is on the line, and he's wavering. Brennan writes a draft majority opinion. Tom Clark, appointee of Harry Truman, writes a blistering draft dissent. And Fortas is so offended by the kind of hysterical anti-communist tone of the dissent that Fortas goes over the majority. So you have a 5-4 opinion by Brennan in early 1967, Keishian versus Board of Regents. And Brennan, he's got a lot of rhetoric about the vagueness and overbreadth of the Feinberg Law, and has some hypothetical questions. Does the teacher who carries a copy of the Communist Manifesto on a public street thereby advocate criminal anarchy? Does the teacher who informs his class about the Declaration of Independence violate the prohibition on believing in or being a member of an organization with revolutionary aims? You're looking at me, so I'm going to try to be very fast. He also basically says, finally, that guilt by association is not an appropriate criterion for public employment, especially in the educational environment, unless there's not only scienter, but an intent, a specific intent to further the illegal aims of the organization. And finally, he picks up on the rhetoric of Douglas's dissent in Adler, and he says, "Our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us and not merely the teachers concerned. And it's a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom." So again, he's merging this notion of political activity by citizens, extramural speech, with this notion of what goes on in the classroom, the core work of teachers. So, questions left open by Kayishian? Institutional versus individual academic freedom. That tension remains unresolved. There's some cases noted in my materials, the Bakke case, the Ewing case, in which the court recognizes the institutional prong of academic freedom, but does not really resolve the potential conflict between the two. Does academic freedom, this special concern of the First Amendment, does it apply to teachers in public schools or only to professors at public universities? And private universities, to the extent that the state is interfering with them. Used to be thought that it applied to public educators, certainly at the high school level. In the courts these days, probably that's not much of a claim that's going to get very far. Does it apply to students as well as teachers? And finally, the questions that that Rick and Teresa will deal with. How does this development of academic freedom under the First Amendment relate to the more general protection, shrinking perhaps, protection of public employees generally in terms of their free speech? And finally, what does Garcetti mean for the future? Is there anything left of the Kayishian ruling after Garcetti? So I'm going to stop and apologize for going on too long, and Rick, please take over.
Thank you. So, as the principles of academic freedom developed over the half century, beginning with the 1915 AAUP Declaration, they changed from professional standards to legal principles recognized by the courts, but recognized in a somewhat uncertain and ill-defined way. That transformation was in part the result of the fact that the 1915 Declaration was largely in response to actions by university trustees and administrators, whereas the threats to academic freedom in the 1950s and 60s came from the government. The courts therefore began to incorporate aspects of academic freedom into the constitutional protection that they were used to applying against government oppression, especially the First Amendment's guarantee of freedom of speech. It is noteworthy that the AAUP was slow to involve itself in that litigation or to adopt the view that academic freedom was protected by the First Amendment, and there are good reasons for that. There's not an altogether comfortable fit between the purposes and principles of academic freedom and those of free speech generally, a point which, if we have time later, I'll come back to. Furthermore, the First Amendment limits the power only of government. Thus, private colleges and universities are not restrained by its terms, and their faculty members are not protected unless the interference comes from the government itself. The incorporation of academic freedom into constitutional doctrine is a mixed blessing for an additional reason. The authors of the Declaration thought of faculty as members of a learned profession, subject to its own traditions of peer review, academic discipline, and service to the community. However, faculty members at public universities are also public employees, and therefore risk being governed by First Amendment jurisprudence applicable to such employees, which even during the most liberal period of the Warren Court provided less protection to free speech by faculty than to citizens generally. Of course, for most of our history, public employees enjoyed no protection at all against retaliation for the exercise of their constitutional rights, whether the privilege against self-incrimination, the right to due process, or the right to free speech. The reigning doctrine was that public employment was a privilege, not a right, and that public employees could be discharged for any reason, including the exercise of constitutional rights. The Supreme Court began providing protection to public employees exercising their constitutional right in the 1950s and 60s in some of the cases that you just heard about from Marjorie. The Watershed case defining the First Amendment rights of public employees was a case called Pickering versus the Board of Education, decided by the Supreme Court in 1968, just after Kenesha. In that case, a public school teacher was dismissed from his position for sending a letter to a local newspaper in connection with a recently proposed tax increase that was critical of the way in which the school board and the district superintendent of schools had handled past proposals to raise new revenues for the schools. The school board dismissed Pickering after a hearing in which it found that his letter to this local newspaper was detrimental to the efficient operation and administration of the schools of the district. The Supreme Court began by reaffirming its prior rejection of the theory that a public employee can be compelled to relinquish First Amendment rights that he or she would otherwise enjoy as a citizen to comment on a matter of public interest in connection with the operation of the public schools in which he or she works. However, the court continued, at the same time, it cannot be gainsaid that the state has interests as an employer in regulating the speech of its employees that differ significantly from those it possesses in connection with the regulation of speech of the citizenry in general. The problem in any case is to arrive at a balance between the interests of the teacher as a citizen in commenting on matters of public concern and the interest of the state as an employer in promoting efficiency of the public services it performs through its employees. So that's the balancing test that the Warren Court established in Pickering, and as you can see, it balances First Amendment rights of public employees in a way that would not be constitutionally applicable to citizens generally. The court went on to analyze the contents of Pickering's letter, which it described as essentially a criticism of the board's allocation of school funds between educational and athletic programs. Never changes. And of both the board's and the superintendent's failure to inform the district taxpayers of the real reason why additional revenues were being sought. The court was careful to note, quote, "The statements are in no way directed towards any person with whom Pickering would normally be in contact during the course of his daily work as a teacher. Thus, no question of maintaining either discipline by immediate superiors or harmony among co-workers is presented here." In several subsequent cases, the Supreme Court upheld the free speech rights of public employees, most of whom really coincidentally happened to be school teachers, and in one case, college teachers. For example, in Perry v. Sindeman, a case decided in 1972, the court reversed the dismissal of a case brought by a community college teacher who alleged that he was not rehired because he had testified before the state legislature in favor of elevating his college to four-year status, a change that was opposed by the Board of Regents. By the way, that court held that it was irrelevant in that case to First Amendment claims that the teacher did not have tenure and that his contract had expired. In another case in 1979 called Givhan versus Western Line Consolidated School District, the court held in favor of a school teacher who was allegedly fired because she complained to her principal about actions that she viewed as intended to sustain the continuing segregation of the school. The court held that in that case that it did not matter that her speech was made in the context of a private communication rather than a public statement. The pendulum began to swim back the other way in a case called Connick versus Myers, decided by the Supreme Court in 1983. Myers was an assistant district attorney in an office headed by District Attorney Connick. When Connick proposed to transfer Myers to a different division, she strongly objected, expressing her views to several of her supervisors, including Connick. Myers then did what must have clearly been designed to get her fired, I'm afraid. She then prepared a questionnaire that she distributed to others in the office, questioning the office's transfer policy, office morale, the need for a grievance committee, the level of confidence in supervisors, and whether employees felt pressured to work in political campaigns. Connick then told Myers that she was being terminated for refusal to accept the transfer and that her distribution of the questionnaire was an act of insubordination. The Supreme Court, in a 5-4 decision, reversed the lower courts and upheld Ms. Myers' termination. The court applied the balancing test set forth in Pickering. However, it held that except for the question in the questionnaire regarding pressure on employees to work in political campaigns, the questions posed, like her objections to the transfer, did not involve speech as a citizen on a matter of public concern, but rather only as an employee upon matters of personal interest. The court defined a matter of public concern, in really a definition that's kind of circular and it's not very helpful, as one, quote, fairly considered relating to any matter of political, social, or other concern to the community. That definition, according to the court, and that sort of supports Sam Estreicher's comment earlier that legal standards are often window dressing. That definition, according to the court, and this perhaps is a little more helpful, reflects, quote, the common sense realization that government offices could not function if every employment decision became a constitutional matter, end quote. The court further held that the limited First Amendment interest involved, remember the court did say that the question in the questionnaire about feeling pressured to participate in political campaigns, that was a matter of public concern, and that's why the court referred to it as a limited First Amendment interest. The court further held that the limited First Amendment interest involved did not require Connick to tolerate action that he reasonably believed would disrupt the office, undermine his authority, and destroy the close working relationship within the office. And that conclusion, remember, is in the context of a district attorney's office, a public prosecutor's office, a point I'll return to in a minute. The holding in Connick, and in particular its view of what constitutes a matter of public concern, has led many lower courts to reject First Amendment claims by public employees. In the context of university, that has been the result most particularly with respect to faculty speech relating to internal university matters. Examples of such speech that have been held not to be constitutionally protected, that is, not to involve speech on a matter of public concern, include the following: statements in connection with counseling students and student activities, a librarian's recommendation of a book for freshman orientation, a faculty member's complaints to union representatives and a grievance officer, this is all one, accusations that another professor interfered in committee matters, and other complaints about internal matters to higher-ups within the department, the college, and the university. Footnote, that actually was a CUNY case. And a faculty member's request for and distribution of salary information. All of those things were held to be matters purely of private interest. By contrast, some courts have found some of the speech of faculty that's on the borderline between what's clearly public and what might be considered private in two areas. One was a professor's comments on administrative decisions regarding allocation of the university's resources, and another was a professor's comments on the alleged lowering of academic standards. Those were held to be matters of public concern and therefore subject to First Amendment protection. So let's take stock at where the law stood with regard to free speech rights of public employees before we get to Garcetti. First, the Supreme Court has established a firm but hardly clear distinction between speech as a citizen on matter of public concern and speech as an employee on a matter of personal interest. Only the former merits constitutional protection. It is noteworthy that none of these cases dealt with the first two aspects of academic freedom to which Marjorie adverted early on, namely teaching and scholarship. Rather, to the extent that these cases involved teachers at all, they dealt with their right to speak as citizens, the third prong of academic freedom. There's almost no case law pre-Garcetti considering whether the content of classroom instruction or scholarship is subject to the same standard. That is, whether it must be shown to involve a matter of public concern. Now, of course, a lot of what professors teach does appear to be a matter of public concern, but maybe not all of it. I mean, maybe some obscure debate on French, literary theory might not be considered a matter of public concern, and if you got fired for having the wrong view on that arcane subject, a court might find that it's not a matter of public concern if this line of cases applies to teaching at all, which so far we've seen, at least pre-Garcetti, we saw none of. Thus, even if the Supreme Court eventually decides that Garcetti is not applicable to faculty at public universities, which I think we all hope it will, it is unclear to what extent academic freedom is protected by the First Amendment in the core areas of teaching and scholarship under the prior doctrines in Connick and Pickering. Second, once it is determined that the speech in question involves a matter of public concern, kind of a threshold question under Connick, in applying the Pickering balancing test, the Supreme Court has placed significant weight on context. And this is sort of both a good and bad thing. Connick involves speech within a public prosecutor's office. Given the somewhat quasi-military nature of a public prosecutor's, I worked in one, so I can speak with some authority on the subject. It's not surprising that the court gave deference to the district attorney's concerns about office relationships and discipline. But many of the prior cases, prior to Garcetti, involved public school and college teachers. And there the court seemed a little bit more skeptical about claims of alleged harm to morale and discipline in those contexts. And so the possible good news, and it's reflected, as you'll hear in a moment, in the footnote in the majority opinion in Garcetti, is that the Supreme Court is sensitive to context. It does understand that colleges and universities may not be exactly the same creatures as public universities, and that gives us a little bit of hope. Of course, I've spent a third of my career in a university, and a third as a public employee, and a third in private practice. And so I have some sympathy for the public employees as well as for university faculty. And it's not just public universities, of course, that are different. I mean, there's a range of government law offices subject to sort of differing levels of discipline. One wonders, for example, whether scientists working for a regulatory agency are subject to the exact same discipline as an assistant prosecutor in a DA's office. But for today's purposes, we're concerned only about faculty, and so I'll stop there and we'll move on to Garcetti itself.
Good morning. Can everyone hear me? Yes. Okay, great. So Garcetti, who was the one who started all of these problems for us? This case originated also in a deputy district attorney's office in Los Angeles. Richard Sabelis was the deputy district attorney who drafted an affidavit in which he questioned whether a search warrant had been properly issued and outlined why he thought it had not after doing some investigation. His superiors disagreed with him. Eventually, somehow, the defendant's attorneys found out about this memo, called him as a witness, and so he had to testify about his concerns. The court held the warrant was valid, and the search warrant was, everything that he searched for was allowed to come into the case. Following these events, however, the district attorney's office decided to first transfer him to another position, eventually transfer him to another office entirely, and finally to deny him a promotion. And so he sued, alleging that these actions were all retaliation for his First Amendment right of speech in writing this memorandum and raising issues of which he had concern. It went all the way to the Supreme Court, and the Supreme Court rejected the constitutional claim. saying for the first time that if this speech in question was a part of the official duties of the public employee, then there could be no First Amendment protection. So this added a new element to the test, to that threshold question of whether there is First Amendment protection for speech. The main concern for the court seemed to be that it didn't want to place public employees in a substantially better position than their private counterparts for the same conduct. At least that was the reason the majority gave. So before I go into the whole issue of how does this apply in the higher education context, I did want to emphasize that certainly Garcetti was not overruling the previous precedents that have been discussed here by Rick and Marjorie. When, if it's speech as a citizen, as a private citizen, Garcetti was not overruling Pickering, the case in which the public school teacher, as a citizen, wrote a letter to the editor. I don't believe it would overrule a different case where there was speech at an employment situation such as Rankin, where there was a clerk in a constable's office who spoke privately with another employee, sort of talking about her own political views. It had nothing to do with her role in that office. And the court said there that she was speaking as a private citizen and she cannot be fired for a personal conversation that she has with a co-worker. So none of that was overruled. But what happens with Garcetti and its application to the higher ed and to university and college settings? Justice Souter, in his dissent in that case, raised the issue that the Garcetti rule, looking at part of the official duties, was of such a wide scope that he worried that even the, quote, teaching of a public university professor, end quote, could be held to be part of their official duties. And so now you're teaching in a classroom. Does that mean that what you're teaching about in your class could form the basis for you to be fired and you have no First Amendment protection for that? The majority felt it had to respond to that and responded, dismissing it in a short statement, saying that the court had not decided yet whether the Garcetti rule would apply in the same manner to a case involving, quote, speech related to scholarship and teaching, end quote. So the court clearly recognized that there was a different circumstance, different issues that applied in the higher ed setting. But the Supreme Court is notorious, as are all courts, in ever reaching an issue when it doesn't have fact patterns. So it's not a surprise that this issue is left open then for the lower courts to struggle with before it goes back up to the Supreme Court. So what you have now are two tests, essentially. Before I talk about how Garcetti has been applied in the courts, if the court, as a threshold matter, holds that it is part of the official duties, that's the first question, then there will be no protection. If it's not part of the official duties, then I believe it goes back to the Pickering test, or the balancing test. The other thing that the Garcetti court addressed is what does official duties mean? Because you can see where that could create a problem. And the one thing that the court did sort of forecast and was aware of becoming a problem is who defines what the official duties are. So if you have a description in some sort of a manual, employee manual, that describes the official duties, it could be described very broadly rather than to be tied to what the employee is actually doing. And the Supreme Court in Garcetti made it very clear that the written official duties is not what lower courts should be looking to when they're deciding as a threshold matter whether this is protected speech or not. And the court described it as a practical test, a case-by-case inquiry that has to be applied based on what the employee actually does, not on what some written job description might say are the official duties. That was good news. So what have the courts done in terms of applying Garcetti? It will come as no surprise to you that I don't think Garcetti should apply in the higher education setting. So as I discuss what the courts have done, I've decided to give you, the cases where they have applied it and where they haven't, and I'll start with the bad news first. In one case, which actually Rick alluded to, there was a case that came out of Ohio State University, and a instructor who was part of the head of reference, was also head of library instruction, was on a committee with other faculty members and administration members that were selecting a book that all the freshmen would review or read as part of their orientation. He suggested several titles, one of which included The Marketing of Evil, which many of the other faculty members protested and didn't want to be included as part of it. It became a very controversial issue. It caused a heated debate among the committee members and beyond that. Because of the controversy, eventually the head of reference and library instruction, who had made the suggestion, left the university and sued the university on a charge of constructive discharge, feeling that he couldn't stay based on what had ensued after he made his suggestions. The Sixth Circuit rejected his argument, holding that since his selection of the book, which led to the controversy, which may have led to his discharge, was part of his official duties, something that he was asked to do, and because of the role that he had at the university, that Garcetti would apply. Even more problematic, I think, that case, that was problematic, but also the court applied a previous Sixth Circuit opinion that it had, that saying that the teachers can be held responsible and don't have control over curriculum. But the case that they applied was something that was for elementary and lower, school cases. So it really should not have applied in the higher ed context. But that was a very problematic decision there. The Seventh Circuit as well has decided or come out in favor of applying Garcetti in the context of higher ed. In this case, they considered the allegations of a tenured professor at University of Wisconsin-Milwaukee who was in the College of Engineering and Applied Sciences. He had argued that his pay was reduced and a grant that he had from the National Science Foundation had been terminated in retaliation for his complaining to a university administrator that some of the dean's conditions had violated the grant terms. And when he did that, the grant was taken away, he alleged, and his pay was reduced. The Seventh Circuit wouldn't consider the case, concluding that the administration of grants was part of a tenured professor's official duties, and dismissed the First Amendment retaliation claim. In a lower court that's in the 11th Circuit, similarly, a court considered whether a tenure-track assistant professor of English at the University of South Alabama had raised a claim that would be protected by the First Amendment. She had been informed that she would not be reappointed, and she filed suit alleging that the reason that she was told she wouldn't be reappointed was that during a faculty meeting, she had objected to the lack of diversity among candidates considered for an open position in her department, and that was the reason. The court rejected the argument that that was protected speech, held that she voiced her complaints there in her role as a faculty member, as an employee rather than as a citizen, and because it was her role as an assistant professor to take place in the faculty hires, she therefore that was not protected speech, and Garcetti applied. Now the good news. I think the tide has been turning. Those were earlier cases. We have a couple of cases from 2011 and one from just in January 2014 where the courts have looked at it differently. So the first case is a case that arose in a lower court in Louisiana. Professor Van Heerden was a coastal geologist, a hurricane researcher, and he was a full-time faculty member at Louisiana State University, and he also co-founded the LSU Hurricane Center, and he was serving as its deputy director at the time when Hurricane Katrina hit the Gulf Coast. He was selected to head a group of scientists that were charged with investigating the causes of the extensive flooding, what had happened post-Katrina. As a result of his research, he became very concerned, and he began speaking out publicly, saying that the U.S. Army Corps of Engineers could have prevented all this, that they had failed to properly engineer the levees, and if they had done that, there would have been the extensive flooding, death and destruction that had happened in Louisiana. In fact, he went on to publish in May of 2006 a book called The Storm, in which he, again, outlined his theories about what had happened. In the meanwhile, while all this is happening, while he's speaking out and he's writing the book, LSU is repeatedly ordering him to stop making public statements. Don't make public statements, you can't talk about this, don't do this. He ignores them. So initially, he's stripped of his teaching duties. Finally, after he refuses to stop, publishes the book, they refuse to renew his contract after 20 years of employment with the university. He sues LSU, raising a number of allegations, but for our purposes, one of them was that he was retaliated against for exercising his First Amendment right to speak out. Some of the claims were dismissed, but the bottom line is that the court ruled that Garcetti cannot apply to this type of speech, that should not apply to the university setting. And there was some very important and strong language talking about the fact that academics, by the very nature of their employment, will sometimes be engaged in unpopular speech. But if universities want research to continue, they have to be cognizant of the importance of allowing that type of speech. So again, the tide is turning a little bit, and the court here is saying, no, Garcetti cannot apply to this. The court did, however, because lower courts like to hedge their bets, and they don't like to be overturned, go on to say that even if Garcetti applied in this case, clearly this professor was speaking as a citizen. He was out there making public speeches. He wrote a book. He wasn't speaking as part of his official duties. So the court, in that sense, even if we were to apply the Garcetti test, said this would be protected speech. Of course, in all of these cases, as Rick and Margie have alluded to, that's only the threshold question. Even if you show that it is protected speech, you would have to be able to show in court that that was the reason why you were terminated, or your pay was reduced, or you were, there was some adverse employment action. So we have a couple of other cases where the courts have also said that Garcetti should not apply. One is in the Fourth Circuit. So we now have not just the lower courts taking a different position, but now we're going to have conflicts in the circuits. The Fourth Circuit, in the Adams case, considered the situation of a tenured assistant professor who applied for a promotion to full professor. So this is part of his tenure review, part of his promotion application. He had submitted some non-peer-reviewed columns, books, and other articles and things that he had written. And a faculty panel thereafter denied his request for promotion. He argued that it was because of the views that he had taken in the materials that he had submitted for review and in the work that he had written, his books, his articles, and it was based on the content of the speech. The Fourth Circuit held that Pickering should apply and not Garcetti because Garcetti should not apply to academic research and to teaching and scholarship. And that certainly the review committee could be looking at the quality of his scholarship, but should not be looking at the content. So if he could show that it was based on the content, again, he met the threshold question, but if he can now show that it was based on the content of his speech, that would be a First Amendment violation. And then the most recent case is the Devers case, which is a case from the Ninth Circuit. A tenured professor at Washington State University, who was part of the Murrow School of Communications, had published a pamphlet regarding the restructuring of faculty at the university in that particular school. He called it the 7-step plan, and it was very critical about the way things had been structured, how they should be restructured, and he faced retaliation for that and sued. Initially, the district court said it was part of his official duties and not protected speech. But the Ninth Circuit reversed. And in an opinion that we actually had as part of the handouts that you can review, The court was, in very, very strong language, said that Garcetti cannot, consistent with the First Amendment, apply to teaching and academic writing that are performed pursuant to the official duties of a teacher and a scholar professor. The court held that the 7-step plan, which was talked about how things should be restructured at the school, was related to scholarship and teaching. So went on to one of the other issues that are raised here. You know, even if we say scholarship and teaching is protected, what is encompassed within that? In this case, the Ninth Circuit said it was a proposal that would have substantially altered the nature of what was taught at the school, would have changed the composition of the faculty, and who should have taught it. And that is part of the academic, teaching, research responsibilities, and should be protected speech when a professor addresses those issues. So now the case, again, because this was just a threshold matter, has to be remanded back to the district court to determine, under Pickering, the balancing that Rick talked to us about, how you balance the First Amendment rights of the professor against the interests of the university in what you would call, I guess, the efficient management of the employment situation. And then, of course, whether that was the reason for the retaliatory or adverse employment action. So that is the most recent case that we have. So what will happen next? I mean, it seems that the Supreme Court at some point is going to have to answer its unanswered question. And certainly that may be sooner rather than later, now that we've seen that circuits are in direct conflict as to how they're applying it. But one other issue that we wanted to talk about today is the repercussions of Garcetti going beyond just in the classroom and on the campus to social media issues. And I was going to turn it over back to Marjorie to talk about a recent social media policy that seemed to be trying to tie itself to the language in Garcetti pretty clearly.
Okay, thanks, and we should open it up too. But let me first open it to the panelists and then for your comments as well. This is in the materials. It's an example, some might say rather extreme example, of both post-Garcetti, I heard Liesl say straitjacket, just as Warren's metaphor, but the ways in which some university administrations, and in this case the Kansas Board of Regents, are taking advantage of what they think or hope Garcetti means, and the more general challenge that is presented by tweets and Facebook and all these other social media sites, which are communications in which are distributed to a worldwide audience as opposed to just the faculty promotions committee. So the Kansas policy is a good opening for debating and discussing some of these issues. And basically what it says is, as a disciplinary matter, a professor can be suspended, dismissed, or terminated if he or she makes improper use of social media. And what does that mean? It means communications made pursuant to an employee's official duties and contrary to the best interests of the university. So putting aside whether this is going to be consistent with First Amendment, there's a little vagueness problem here. What's contrary to the best interests of universities? That can be somewhat subjective. And then there's some examples, including any communication that impairs discipline by superiors or harmony among co-workers. Maybe a little reference back to Pickering. So why don't I start by asking Rick, what do you think of this? The AAUP and lots of other groups have filed, have submitted objections to this. My understanding is it's being reviewed by the Kansas Board of Regents. What do you think?
I'm not the best person to comment this. I've never tweeted in my life. So I really should pass on this question, other than if you take out the technology involved and just view it under other forms of communication, it seems to be pretty clear that it's a violation of both academic freedom and the First Amendment. unless you think Garcetti should be applied to public universities. By the way, a point about the balancing test, which comes up again and again, even in the post-Garcetti cases, I said before that context really matters, and the balance is supposed to be between the rights of the employee to comment and the efficient administration of the agency. It seems to me one could argue that the efficient administration of the university is an oxymoron, and that there's nothing to balance on the other side. Or putting it in a more positive way, universities are created to encourage debate and disagreement, and therefore, if you get past the Garcetti obstacle, it should be very easy to win on an appropriately applied balancing test.
And I agree with Rick. I mean, it seems to me that that's the issue. Garcetti should never be applied in a higher education setting. It just doesn't make sense. And I think that the court was signaling that, I think. And I think if we go back to the cases that Rick and Marjorie discussed earlier this morning, the court has recognized the importance of protection for debate and disagreement and unpopular views in the higher education setting, and that is ultimately where it needs to go. Unfortunately, given the way our system operates, the court wasn't going to decide that until it had that fact pattern before it. And so we wait, and then hopefully we get the result that should be.
Okay, we have 15 minutes left with our Universities Without Walls and the way social media is being incorporated not only into the classroom and discussions that faculty members may have with students, or disagreements faculty members may have with one another, or statements by a disgruntled employee on social media. The question is whether it's public statement or a private statement. Can you have a private conversation on social media? Does anybody have any questions or scenarios that they would like to pose to the panel in dealing with this issue and social media? Yes, sir. Could you please stand up and identify yourself?
My name is Dwayne Schaefer. I'm a counselor at Long Beach City College, and I'm also a Community College Association Secretary, which is a state organization in California. My question is, I know we're talking cases and law and legal language and what have you, but I didn't hear anyone say, or maybe this doesn't exist, that if one's contract covers academic freedom, I guess you gotta get pretty explicit, does that override these case laws that has come into play?
Yes, I definitely, and that's what needs to be done in the meantime until the courts resolve it, is that Garcetti, opened up this question. Some of the courts haven't dealt with it the way we believe they should under the jurisprudence, but in the meantime, certainly, as awareness, professors become aware of the situation and how the courts haven't been going that way, you can certainly have that as part of a contract and part of the faculty handbook. And have an agreement that the university will treat it as protected speech, would be my view.
Yeah, and it's also worth remembering that in a conflict between a private university and administration and employees, the First Amendment doesn't apply. So all you've got is your contract rights, basically.
Just one additional point. For some universities like CUNY, there's also a board bylaw on academic freedom, which might give rise, in the appropriate circumstances, to either a grievance under a collective bargaining agreement or to a lawsuit for violating a board bylaw.
Sir?
In the public setting, I don't know if this is true elsewhere, but in New Jersey at least, academic freedom has actually been found by the courts to be a prohibited subject of bargaining. So you can't use that. Now, I think your suggestion, obviously colleges and universities can still grant academic freedom within their governance policies, and it can be under certain circumstances enforceable. My other question that's a little narrow, that I guess was a comment, but my question is dealing with freedom of speech in the governance context, when you're talking about terms and conditions of employment, I guess another avenue, at least if you're talking at private universities, is that if you make sure you're doing it in concert with others, then you're presumably covered by federal labor law. Do people have thoughts about that?
Well, I have a thought about the first part of your statement, which is important because it reminds us that there are also 50 state constitutions. And what I'm inferring is that the New Jersey Supreme Court has decided that under its state constitution, academic freedom is sacrosanct. And it doesn't matter what the Supreme Court of the United States says about the First Amendment. So there may indeed be additional, no, I'm wrong? Is it exactly the opposite?
That's not my understanding. It's that they think the political process is sacrosanct and that they don't want to leave
Okay.
issues to collective bargaining where they think it should be determined by boards of trustees that they claim are more answerable to the polity.
Okay. There was once upon a time, a New Jersey Supreme Court that was interpreting its state constitution in a more liberal manner than the First Amendment had been interpreted by the U.S. Supreme Court, both with respect to the substantive right and with respect to whether it applied to private universities such as Princeton, in the case I'm thinking of. So there may be additional rights under state constitutions.
And again, as Marjorie said, when you're talking about a private university, it is going to have to be through contract because the First Amendment, all of this that we've been discussing is in the context of public employers.
Yes, Ricky?
One thing I would add is that the protection under contract should be as specific as possible. I mean, a contract that simply says we protect academic freedom, then is going to be subsequently have to be interpreted. What does that mean? Does it mean specific things? And I'm thinking of one particular case where it's not a contract, it's university policy. The University of California generally has had strong protections for academic freedom. When Garcetti came down, however, there was a case that Teresa didn't mention, the Hong case in the Ninth Circuit, where a professor at UC Irvine claimed that he had been denied a salary increase because of his outspoken nature, I guess. He was kind of a pain in the neck, I think. Well, you know, that's the way laws are often made, but especially First Amendment law. But and he sued and said that, you know, it was his right to speak, and the court applied Garcetti and said that it, now, as that's moving along through the courts, the University of California, in a typical very slow and tedious academic manner, is gradually going through a lengthy process through their academic senates, et cetera, to change their policies to explicitly write in that among the rights to academic freedom are the right to speak out in the university on university matters of policy, et cetera. I can't remember the exact language. And only last year was that finally approved by the Academic Senate and then endorsed by the Board of Trustees of the University of California. So that's now part of their, I guess it's the faculty handbook because they're not union, but it has the strength of a contract for them. What that has meant specifically to the Hung case, I frankly don't know. I don't even know if that litigation is still moving on or whether it was settled or what have you.
And Hank reminds me, I should say that what I gave you was a sampling of cases. There are many, many cases that have raised this Garcetti issue, but I wanted to give you a flavor of how the courts have been dealing with it.
I deal with a lot of disciplinary matters, and in particular, social media has come into that quite a bit lately. How would any of you feel about a posting of a photo, no written words? Is that photograph still worth a 1,000 words?
Sure, if it's communicating something and it's meant to communicate something, I would say it's protected by the First Amendment.
Okay, so then you get into more narrow issues. Maybe is the post by someone who identifies themselves as a university employee, let's say it is, and the post is of something that happened at work. What if it's a post of something that was protected? There are other people involved in it, and they didn't agree to the posting of that photo.
Well, Justice Black used to say, the First Amendment says Congress shall make no law, and that means no law, but he was wrong. There are lots of exceptions to the First Amendment, invasion of privacy just being one of many. The person did not have the authority to post that private photo. That's not protected by First Amendment.
How do you feel about people who just aren't getting along with one another, and what might happen in a faculty meeting is then posted out on the internet, and people are identifying themselves as faculty members of your institution, and now the public is seeing a public bickering contest amongst employees? Is the administration allowed to consider that as negative impact? Should they be concerned with what people are seeing out on the internet?
You have an interesting job.
Yes, indeed, I do.
I don't think of the Pickering balancing test.
Well, I think before you get to that, is the question under Connick whether it's a matter of public concern. And although I'm not exactly thrilled with the result in Connick, I see some aspects of it that make sense. And the idea that not every petty employment dispute becomes constitutionalized, it seems to me is an appropriate caution. It's hard to see the First Amendment values protected by calling your department chair a son of a bitch. Okay, and if you do so, no matter how good the grounds are for doing so, it's just not a matter that federal courts are going to really view as they just don't view themselves as the appropriate forum for adjudicating those kinds of disputes.
Does anybody else have any questions? Yes, sir.
You had spoke to the case earlier about at the University of Kansas with the associate professor who posted a tweet that went viral. And I'm wondering, given the political structure of Kansas today, it's moved to the extreme right, Senate, the House, the governor. It's like a pro-gun state, and it's I think a number of the elected officials are receiving campaign contributions from the NRA. Had this tweet had not been directed towards that side of it, do you think it would have still had the same reaction, nationwide? It did.
Okay, you're referring to what was, I think, the genesis of this very broad Kansas Regents policy that I think the entire panel agrees is unconstitutional. The genesis was some tweet, and I don't remember what the content was. It sounds like it had to do with gun control, perhaps.
Well, if I remember correctly, he said something about may your son or daughter be the next
Yes.
to go. And I think he directed towards maybe William LaPierre from the NRA, maybe I think it was.
Okay, so there's a whole lot of issues with respect to whether that particular comment, and that comment had been made by somebody within your jurisdiction. Does it have First Amendment protection? Is it a threat? Is it a matter of public concern? Lots of issues that could be argued over with respect to the particular comment, but it wasn't a justification for creating a policy that is so broad and chilling. And of course, part of the problem here is the fundamental illogical dichotomy that the Supreme Court created, really starting with Connick. Either your speech is pursuant to your official duties, or it's on a matter of public concern. And of course, as we know from the academic freedom context, it can often be both. So that's how the Supreme Court will paint itself out of the corner it's painted itself into with that false dichotomy. Stay tuned.
Okay, I believe our time is up. If everyone would please fill out your evaluations, and if you want CLE, you need to sign out as well. Thank you, everyone.